me. I think a trier of fact is gonna say, guess what? There's a line that
Why don't you just go get to a
All
trial?
rise. Circuit Court for the State of Oregon for Lane County is now in session. The Honorable Jay McAlpin presiding.
Please be seated.
Thank you, Your Honor.
Here on State of Oregon versus Andrew Glenn Clark, 2113-14234. Here on defendants Demurrer. I've read the Demurrer and the attached memorandum, and I've read the state's response. Mr. Bonds.
Thank you, Your Honor. May it please the court, may it please counsel. So we're here on Demurrer today. No, you can sit down, please. We're here on Demurrer today. I filed a written document. I assume the courts had the opportunity to review those documents. States filed a response to those documents. And I'm going to address a couple of points. I think the Demurrer is in a box. I think it's probably sufficient for my main arguments. But let's address the issue of whether Demurrer is untimely or not. It's clearly not untimely when it goes to the issue of does the information state facts that constitute an offense. A Demurrer can be made at any time up through the case in chief, and there's several cases on point. State v. Wimber 315 OR 103, State v. Mack 20 OR 234, State v. Zimber 5 OR Act 253. All these cases, Demurrers are made even into the fact that even after the state's case in chief during trial. So I think the Demurrer is not untimely as it goes to the whether or not the essential elements. So that moves us to step B in the analysis of whether or not, or what can be demurred. And it's pretty clear from the state's filing and from my filing that the essential elements must be pled. We move on beyond the essential elements, and then we determine whether or not threat is an essential element. I think Rangel answers that question definitively. It says threat has to be an essential element in this case. Rangel identifies and actually articulates what's required to be an essential element. It has to be unequivocal threat. It has to be there has to be a bunch of sub-elements involved in what is a threat. We don't have to go into the sub-elements in this case because there has been no allegation that any threat was made. This case, for factual background purposes, this case involves 10 faxes to the Ogletree firm. Those faxes contain a bunch of, you're interrupting me in my presentation, which is probably not good. It won't be appreciated by me or the court. Those faxes were sent. There is no allegation that any personal contact or anything other than communicative has been done. Therefore, I believe that threat is an essential element. It's certainly one that's going to have to be proven by the state in trial. It needs to be in the information file. I have several cases on point. The first is State v. Ryan. That's 350 OR 670. It's a 2011 case. It pretty clearly indicates that when free speech, Article 1, Section 8 of the Oregon Constitution is involved, there's a direct conflict with the stalking statutes. And when that's the case, there's an elevated proof requirement, and that proof requirement requires threat, and it has to be unequivocal. It has to be objectively reasonable for the victim to believe that he or she is being threatened with imminent, not just serious physical harm, but imminent serious physical harm. And it simply, well, those are the sub-elements of that offense. There's certainly a bunch of other cases. I'll give a couple more just to kind of flush it out a bit more. State v. K.O., that's 245 OR App 403. Again, another 2011 case.
Did you say 235?
I said 245 OR App 403. The next case I would give you, well, certainly you got Rangel in there. I've already cited Rangel. The other one, State v. Shields. And again, this is a 2002 case, 184 OR App 505. In all these cases, motions for acquittal were made on the issue of whether or not threat was proven at trial. I think it's pretty clear from reading those cases that the analysis of whether a threat was proven at trial was the key issue in deciding whether a motion for acquittal was to be granted or not granted, makes this an essential element of this offense. So
let me ask you this, Mr. Bond.
Sure.
Isn't it possible for a hypothetical case to be subject to a well-taken, granted motion for acquittal, but not demurrable under this theory?
The answer to your question would be yes, if there was facts at trial that didn't prove one of the elements. That's for a motion of acquittal. But the issue here is whether or not it's an essential element. Clearly, anything that would be for a motion for acquittal, any element that wasn't proven at trial, certainly I would assert that that becomes an essential element of the offense itself. Therefore, I mean, if it was an essential element, then there would be no ground for a motion of acquittal after the case in chief of the state. Was I clear there, or was I unclear? Okay. So those are my basic points here. There's some other stuff that state clearly just gets wrong in its response. It quotes some language that I simply did not state. Something about, let me pull that filing up here. There's a little bit of a mad dash to prepare for this. I apologize. In the state's response, they talk about a corporation cannot be a victim. They quote something that I never said. I don't know what that's about. By definition, cannot be stalked, assaulted, raped, or murdered. I never talked about anything about assaulted, raped, or murdered. Certainly, it's not in my motion for demurrer. My point in saying that the state goes into a kind of a convoluted person theory, and that a corporation can be a person. It's pretty clear on person crimes, I think, that a person is an actual real person, not a corporate entity. I don't think there is any other reading of the law would result in absurd results, and certainly the legislature didn't intend to have absurd results. I'll give a couple examples here. In the case of stealing Kmart's computer, that's clearly a theft, but it's clearly not a kidnapping. There's no kidnapping when you go in and steal the computer from Kmart. Kmart is not a person. The equipment that they operate is not a person. So clearly kidnapping is a person crime that require a real person, not a corporate entity, to be kidnapped. So I don't put much credence in the state's argument in that regard. Stalking, same thing. I think you can trespass pretty clearly onto a corporate's grounds. You can perform a variety of torts on a corporation's ground, but you certainly cannot stalk a corporation. Beyond the elevated pleading requirements involved in communicative stalking, I don't think a corporation can feel anything, much less feel the imminent threat to serious bodily harm that's required under the statute to make a threat. Clearly there are civil remedies that can apply here, and there's a variety of civil remedies that probably would be applicable in this case. But we're not here to talk about civil remedies, we're here to talk about criminal remedies. And I think that's all I have right now. Unless you have some questions, Your Honor.
I don't. Mr. Hassan.
Judge, my response kind of speaks for itself. I tried to keep it relatively limited, but I would say that it appears what the defendant's inviting the court to do is to, in fact, do an analysis as to whether or not there's sufficient evidence to support the charge given the Rangel case and its progeny. And the fact of the matter is that's not what a demurrer is. The demurrer in the previous case, in the Rangel case, had to do with deciding the constitutionality of the statute. And the Oregon Supreme Court decided that the Constitution does not prohibit this charge, that it's not overbroad, and that it can be cured by adding those additional requirements if the communications, the contact is by communication only. That can be accomplished by an instruction to the jury, or if it's a bench trial, the judge taking those matters into consideration. But the counsel cited no authority and no cases that have indicated that pleading a charge with the plain language and the verbatim language of the statute is insufficient to be definite and certain, or to be lacking in putting the defendant on notice what he's charged with. The defendant is obviously on notice what he's charged with, because he's responding to it as if he understands that his repeated communications with this law firm are the subject of the state's complaint. And as such, I think the defendant has failed in those particular subsections that are available to him as grounds for a demurrer under the statute. Now, Mr. Bonds indicates that threat has to be an essential element now after wrangle to the case, and I would suggest to the court that it is, and it's pled that way by pleading that the defendant knowingly alarmed and coerced these people, and that alarm and coercion was reasonable, which are both pled in each and every count of the information. Secondly, Mr. Bonds indicates that he doesn't know where I'm pulling this raped and murdered allegation out of. I'm sure the court knows, because the defendant filed the original demurrer on this, and Mr. Bonds in his memorandum did not say that he was completely supplanting the defendant's motion, merely that he was supplementing it. And so I referenced the defendant's motion in which he said a corporation cannot be a victim because it can't be raped, murdered, assaulted, or stalked. And I indicated I concede that a corporation cannot be raped or murdered, but I don't concede that a corporation can be stalked, because I think the facts in this case indicate that. To the extent the court needs any facts on the record to in which to put the parties' arguments in context, I'd ask the court to take judicial notice of the probable cause affidavit that was submitted in support of the motion for an arrest warrant, which was granted by a member of the bench.
Your Honor, I object to that motion. I haven't been provided that yet. I asked for it yesterday, and it certainly hasn't been provided to me to the date.
No. Probable cause affidavit for his arrest, not for the search warrant.
His original arrest.
Oh.
Yeah. And you have that in discovery.
I do.
All right. And so to the extent that you need to, but from the state's perspective, I don't believe this court should be in the position to try the case as to whether the state has sufficient evidence to overcome those additional burdens that the Oregon Supreme Court has put on communication-based threats. There is nothing in Wrangell nor any other case that I've been able to come across that says that once the court made that decision, as far as the sufficiency of the evidence to support the charge, that it put any requirement on the state to in fact include those as elements of the crime in the accusatory instrument. And as such, it's premature for this court to be making a decision as to whether or not the evidence is sufficient to suggest that the court has, or that the defendant has breached these statutes. I think the court's question to Mr. Bonds during his argument was right on track, that at this point it would be appropriate for the court to disallow the demurrer, but keep in mind that the defendant still preserves his right to indicate that the evidence is insufficient to meet the requirements of Wrangell in relation to his free speech arguments when it comes to the proof at trial. Discovery is not completed in this case. There are more reports that I have to disclose to the defendant. I've recently received some communications from the alleged victims, which indicate that the defendant had been sent correspondence prohibiting his contact with the involved parties, with the exception of one designated attorney in their firm, and the evidence after that shows that the defendant continued to contact multiple parties despite an admonishment to the other one. But the court doesn't have any of that, and the court shouldn't have any of that, is the state's position at this point, because that is for the parties in preparation of litigation. The court's function right now during the demurrer is to look at the charging instrument itself and see if any of those grounds that are laid out in 135-630 exist to grant the defendant the relief that he's requesting, and I suggest they don't. I agree that it's an interesting, novel question whether or not a corporation can qualify as a person for purposes of this statute, but on its face, I'd suggest to the court that when you have a statute in place that says where appropriate, a corporation, a governmental entity, all those different potential parties that represent conglomerates of people rather than just an individual. Person is defined as that under the criminal code. There's nothing under ORS Chapter 163 or specifically ORS 163-732, the stalking statute, that indicates that it has to be an individual human being. And as such, I'm asking the court at this point to disallow his demurrer on that ground as well. Again, as my argument in my response to the defendant's demurrer says, if in fact the court concludes that stalking is not a crime that can be committed against a conglomerate of people like a private corporation, then the relief that the defendant's asking is to demur to the entire charge. I'd ask the court to again disallow and merely allow the state to proceed with the individually named human being, Leah Lively, who is also pled in that particular count. As the court well knows, again, that the name of the victim or the identity of the victim under criminal law is not a material element, and there can be variance in a charging instrument between the proof at trial and what the pleadings suggest without that being fatal to the accusatory instrument, even in trial. And so, again, what the defendant's asking you to do in this case is to wipe out a named victim, and that is not, again, I'd suggest, a purview of something that's contemplated by the statutes related to grounds for demurrer.
The state has indicated that I have cited no cases that require all essential elements of an offense to be pled. I would point the court to U.S. v. Livingston. I have copies here for the state and for the court. In U.S. v. Livingston, it makes it absolutely clear that all essential elements in order to survive a demurrer must be pled in the charging instrument. That's 725 F. 3rd 1141. It's a 2013 case, and that's at 1145. There's no doubt that all essential elements must be pled. The real question is whether or not, in a communicative stalking, whether or not a threat is a essential element. I think after Rangel, there's no doubt about this. It's just zero doubt about whether it's an essential element. Certainly, I would recognize that you could plead. You don't have to use the word threat, perhaps, in a charging instrument. But Rangel gives you a very good definition of what a threat is. And the language used in the charging instruments in this case, at the instant case, does not meet that definition, not even close to meeting that definition. I would go on to say that if the allegations were made here to virtually any judge in this courthouse in a civil stalking order, trying to get a civil stalking protection order, I don't think there's a judge here in town, in this court, that would grant that on these allegations made here, that simply facts were made, they'd want to know about it. Unequivocal threats, they would want additional information before they granted those things. I just don't think it passes muster here. This argument about, well, we can do this all at trial, he's in custody right now, Your Honor. His liberties are being taken right now. He's paid out the yazoo for ankle bracelets. There's a lot of, he has constitutional liberties that are not being taken care of as we speak right now. This is not some abstract theory here. We have a gentleman in custody. Those liberties are protected through the demurrer process, and this is equivalent to a motion, Rule 21 motion in a civil case. This allows the defendant to go and attack the charging instrument, and it's meant to do that, and that's certainly what we're doing here. Lastly, I'll point to this person, plain language. The statutes or the case law is pretty clear. If a word is not defined in the statute, then you use the plain language meaning of that word. I think Webster's clearly says person. I don't have that quotation here for you, but I think the court can do that analysis pretty quickly. But a person is a real body. It's a real breathing, living entity. It certainly is not a corporation. If they intended to make it something more than that, then I think it's on the legislature to go ahead and define it as such. Nothing further, Your Honor.
So a demurrer under ORS 135-630 subsection 4, whether facts alleged constitute an offense, is timely. Mr. Bonds is correct that it can be filed at any time. A demurrer under 135-630 subsection 6, it's whether to make more definite and certain, is not timely because a plea has already been entered. And so I'm just analyzing this under subsection 4, whether the facts constitute an offense. And in this situation, this is a situation in which someone could theoretically agree with every legal position Mr. Bonds has taken, and what would happen in other situations, and still not grant the demurrer. Because this may be a situation in which it's ripe for a motion for acquittal, it may be ripe, or it would have been ripe for a motion to make more definite and certain under subsection 6, but the facts alleged constitute an offense, at least under case law, the way that the case law is pled. I don't have to even reach the portion of a corporation, whether it's a person or not, because Mr. Hasselman's right. The identity of the named victim isn't a material element that could be substituted at any time. Again, Mr. Bonds may want to know who that person is, but that's not the motion that's in front of the court that's timely right now. And so the demurrer under 135-630 subsection 4 is disallowed. There's one other thing that I wanted to bring up. It's my understanding that Mr. Clark is in custody. He was taken into custody on that failure to comply warrant yesterday. I also understand that they have increased his security. The way our paperwork reads on that, so let me go through my whole understanding of what has happened. That when the release agreement was revoked, his security that he has already submitted has been yanked back to the court, for lack of the term of art. I'm blanking on the term of art. Forfeited. So the $20,000 that Mr. Clark has already submitted has been forfeited. And then his security has now been released to $40,000. There is a provision that allows for the court to reconsider the forfeiture of someone's security. If that's going to happen. The way that it reads is it's supposed to do it in 30 days or something like that. My understanding is that it's the criminal team's policy that any motions to reconsider the forfeiture of security needs to go to the chief criminal judge, in this case Judge Vogt, and that she does not believe that you have to wait the 30 days before submitting that paperwork. Does that make sense?
It does, Your Honor.
All right. So that was the one other kind of odd logistical issue that we had that I wanted to address. Anything I'm missing for the state?
Your Honor, I don't believe so. I was looking at the docket. It seemed to me there was...
It was Mr. Cowan's. That's a review hearing.
Oh, I meant just the notes in the docket. Oh, it was noted. I know that was one of counsel's complaints too, that Mr. Clark continues to suffer either paying for an ankle bracelet or being in custody. I would just note, as I guess at this point it's what we might consider dicta, that we were set to be begin trial this week, but the defendant moved to postpone it, and it's been set into January. So I recognize that Mr. Clark maybe not be getting resolution to this matter as soon as possible, but I think it was because he ended up changing attorneys, and that attorney needed more time, and he's postponed that. So part of that, the state doesn't want to accept full responsibility for his continuing ills in that respect, because it was his motion to move the case farther out.
Right. And what I was trying to, hopefully not too subtly hint, is that
I can
there's
put that
things that
motion
you can
in.
work on.
Your Honor, I would ask the court to make written findings on this demurrer, please, so that we can preserve the record here.
All right. Mr. Hassman, would you submit some written findings that you would like? And then I'll try to get those to you in, what, 2 weeks? How much time would you like to submit your proposal?
I will try it. I'll order an audio recording of the court's orders today. So the court's declining to also decide the defendant's subsection 6 argument on its merits.
Subsection 6, I think, is unruling. It's not timely.
Okay.
That's something that has to be entered prior to a plea.
Okay.
And a plea is occurred.
Okay. So you're not getting to the merits on that. You're saying that it's the court's decision that aspect is untimely.
That's right.
And then your ruling on subsection 4 is that the pleading is sufficient.
That's right. All right. Thank you. All right. We'll be in recess.
Thank you.
Can you do the